Every week, Moral Maze, we call it, issues of life, sexuality, morality, and there's so much going on, ain't there? And Jack Fonseca is back from the East, from Campaign Life Coalition. Welcome back to you.
Thank you very much, Michael. Glad to be back.
You look very fresh after such a long journey. What is it, 12 hours?
Well, it's a 28-hour journey.
28 hours?
The flight was 14.
Oh, the flight's 14.
Yeah,
okay,
but,
well,
all the travel in between, it adds up to a long time.
When I said 12, well, 20. Well, let's begin with good old tolerance, you know. United Kingdom, and, there's another story which we can talk about tomorrow, which is, but that's another political one, people losing their foster children. UK court favours man being demoted for a Facebook gay marriage criticism. What's all this about?
Well, this poor man, a 55-year-old father of two, had a job as a manager at this housing company in Britain.
Yeah.
And there's a battle. They're trying to legalize homosexual marriage in Britain.
Yeah.
And he, on his personal time, on his personal Facebook account, he posted his support of the true traditional definition of marriage.
Yeah.
So he found himself investigated by the company's board of ethics. They found him guilty of gross misconduct.
And the phrase, I think, was, gay marriage is an equality too far.
Yes.
They were the words.
Yeah.
Well, it's not exactly Hitlerian, is it?
No, not at all. He's not advocating violence. He's expressing his view that marriage is between a man and a woman, and it's perfectly within his right to do so. But they ended up, his company considered, actually the inquiry said he should be fired. They said, well, due to his long record of service, we're going to demote him from a manager, and he's going to have a 40% pay cut. So
he's 55-year-old
man.
55, two children. He's worked for how many years at the company?
I'm not sure exactly.
More than 20 years?
I think so.
And we're not going to fire you. We're going to cut your salary by almost half.
And demote your position.
Because on a private site, he said, I don't agree with same-sex marriage.
Right.
Good God.
Well, this shows the intolerance and the persecution and tyranny that's coming out of the push for same-sex marriage. Back in Canada in 2005, Bishop Fred Henry from Calgary, he warned, and it turned out to be a prophetic warning, he said the push for same-sex marriage will usher in an era of intolerance and discrimination like we have never seen before.
Yeah.
And it's turned out to be true. In England, as we're seeing in the case of this poor man, and in Canada even, where Damien Goddard, very similar situation, tweeted Rogers Sportsnet broadcaster, was fired for tweeting his support for traditional marriage.
Allegedly for tweeting that. He was certainly fired. There are so many examples of this. And this has nothing to do with the gay community where he was working. I mean, this is, if you're working for an organization to support same-sex marriage and you tweet that you disagree with it, I can see there could be a problem. There's a clash, but this is merely an opinion. This has happened throughout the UK. And you have this idiot Prime Minister in Britain, David Cameron, who says, I support same-sex marriage not in spite of being a conservative, it's because I'm a conservative. What he really means is, I support it because I went to Eton, incredibly expensive elitist school, where half my friends were gay. That's why he supports it. And even, although what is happening, there's 118 Tory MPs, including gay Tory MPs, have said, we're not backing you on this. Yeah. I mean, there's a gay Conservative MP who said, why are you doing this? We don't even want it in the gay community. Why are you pushing this?
Well, if there's any Brits watching this program right now, or British expatriates in Canada, lobby the government, contact the government, tell them to abandon this because it brings persecution and tyranny.
All right. Casey Legler, I am the only woman modeling exclusively as a male. Sounds like my life. What is that, please?
Well, the high fashion industry has shown once again that it's lost its mind. So they've got this woman, Casey Legler, who they've given a contract for her to model men's clothing, just men's business suits and those horrible-looking baggy jeans with the saggy asses.
Really? They still fashionable? Why?
Well, it's obviously not to market the products because she's not convincing at all. If you look at the photos, she looks like a woman.
There's a photo there. Yeah.
And so I think it's Forbes, the legendary Forbes modeling agency, is simply trying to push the envelope again. They're contributing to this push to normalize transgenderism in society through pop culture, of which they're a part.
Well, there was a very strong theory that the reason that so many models, beautiful but very flat-chested and very thin and clothes designed to accentuate, was that there were a lot of gay men designing, and this was what they found appealing. I don't know if that's true or not, but that was certainly a strong theory put forward. It could be more sinister. We're trying to say to people, there's no such thing as difference.
Yeah, she said, I'll give you an example. Casey Legler said herself, she said, what I wish is that we can arrive at a place where nobody judges whether you wear a dress or a pair of pants, because how we define men and women just limits us. And what she's saying is we need to abandon all principles, all guidelines, because they limit our freedom. And that's absurd. I mean,
I think Casey Legler should be defined. I mean, obviously she's an intellectual. She's, professor of physics at Oxford. So I do want to hear.
but we're bodily creatures. Our bodies tell us that we're either male or female. You either have the plumbing or you don't. And even in the case of sex mutilation surgery, you still have an XY chromosome if you're a man, an XX if you're a female. So there's no changing
We don't judge a woman if she wears a dress or pants. That's entirely up to her. We judge people by their actions. And if a man dresses as a woman, he's not saying, I'm comfortable like this. He's saying, I want to make a statement, and vice versa. It's more of it's more complex, less specific with women, because it clearly depends what they're going to wear. But for a man wearing a dress is trying to say something. And if you want to say that, my response is, well, shut up, I'm not interested. But you are making a statement.
Absolutely.
Yeah. What else do we have here? Teen guilty of manslaughter, sentenced to go to church for 10 years. That's pretty harsh. It's in Oklahoma.
Well, as he won this teen won the sentencing lottery. I think it's much cushier a sentence than sitting in a jail cell with a guy named Mo who wants to call you Sally and make you his girlfriend.
And say, wear a dress, please. But a first-degree manslaughter car accident resulted in his friend's death. So it wasn't where he set out to kill someone, but someone died through his irresponsibility. But how can you make someone go to church for 10 years?
Yeah, it seems, I'm all in favor of church, and I'm a Christian. I believe that a personal relationship with Jesus Christ can change people if they take it seriously.
You can't force that, though.
No, you can't, and that's why I would have preferred to see a jail sentence. I think with drunk driving, sentencing is supposed to act as a general deterrent, not as individual rehabilitation. So this sentence lacks that general deterrence effect.
Mind you, I can think of a few churches where 10 years it would be pretty harsh punishment.
Well, and for the ACLU who's complaining about the sentence, it would be harsh punishment.
It would be. Although you could go to United Church and then you'd be made even more liberal. Just very briefly, as we end, we covered what happened in Ireland, where medical incompetence led to the death of a poor woman who was possibly having a miscarriage. We're not sure. It was used to then attack the abortion laws in Ireland. It had nothing to do with the abortion laws. It was medical incompetence. There's an official inquiry into this now, but it's being headed by
a radical pro-abortion activist.
It's government all over, isn't it? Even in Ireland, that's what they do.
Yeah, a doctor by the name of Raju Ratnam, something like that, has been appointed, and he's the president of a pro-abortion advocacy group, of who many members of the international abortion lobby sit on that group that he heads, including Planned Parenthood, the world's largest abortion provider.
It's hard to believe an inquiry into a tragic death, and we should have an inquiry. Who did this? Was it because of the abortion laws? Was it because of medical incompetence? Being headed by, if it was headed by someone who was radically pro-life, equally would say, well, hold on, are you balanced on this? But the other side, and that's fine.
Yeah, well, the fix is in. The government clearly is trying to give the abortion lobby what it wants, abortion on demand. And that's what's going to happen if this guy remains as the head of this inquiry.
Which is not the view of most Irish people. Even those who want some changes in the law do not want a full free abortion. But the views of the people, as we've seen with Rob Ford, by the way, apparently don't matter very much. Thank you, as ever, and welcome back.
Thank you very much.
Come on!
Yeah, that's a shame.
Officer, I was carjacked. I was held up at gunpoint.
All right. Hold it right there.
What?
You're under arrest.
What? No, we didn't do anything.
That's exactly right.
Seinfeld and the Good Samaritan law. Well, those do exist in some places, but it's not really part of our British common law tradition that you must intervene to help somebody. That will change in an Alberta Education Act reform. We've talked about problems with what used to be called Bill 2 in Alberta, and the call that it would have to have homeschoolers, private schools, religious schools put all of their curriculum through the lens of the very political Alberta Human Rights Act. Well, they took that part out, but now, as part of their anti-bullying strategy, they're saying kids that see bullying happening, they're going to have to step in and do something to stop it. The principals aren't stopping it. The teachers aren't stopping it. Now they're going to put the onus on the children, or the children could face sanctions. An interesting report out today from the Institute for Marriage and Family Canada, and we'll post a link to that up at the blog liliespad.ca. There's a lot going on in education, including CBC taking a run at homeschoolers. We'll have to leave that for another day. But it all comes back to the question of control over the kids. Whose kids are they anyway? The educrats like to think that they belong to them, that they are their co-parents. Well, that's not the way one father in Hamilton, Ontario sees it. Steve Turlukas says, as my children's primary caregiver and guardian, I must ensure that my children abstain from certain activities and behaviors. And those activities may include engaging in classes or lessons which promote or encourage views which are contrary to our faith. He's currently in a court battle to be informed on when certain things are taught. How's that court battle going? Well, let's turn to Albertos Polygopoulos, who is the lawyer in that case. Now, Albertos, you were down in Hamilton, Ontario last week as part of this court case. How did things go at that point, and where is the battle at now?
Well, things went well. Last week was really just questioning, cross-examinations on Steve's affidavit and on the Hamilton Wentworth District School Board's representative's affidavit. Things went very well. It was interesting to see what positions they were taking. As you mentioned, Steve is asking for three things, actually. He's asking, one, for a declaration that he is the primary educator of his children. This isn't a novel idea. I wish I could take credit for it. Unfortunately, he does have to request this. The second thing he's asking for is an order granting him permission to have advance notification of certain classes, lessons, and activities that his children will be involved in. Again, this is not a novel idea. It's nothing I can take credit for. And then third and finally, the ability to withdraw his children from certain classes, lessons, and activities which may conflict with his religious beliefs.
So you're saying these aren't novel, but yet to certain people in the educational establishment, it seems completely foreign to them that they would do that. And whether it's in Alberta with Bill 2, and I forget its replacement number that I was just talking about, whether it's in Ontario, whether it's in Quebec with their religious instruction where they teach that everything's the same, there's a common theme, and that is, we're in charge of your children, we'll decide what's best for them, and you'll shut up and take it. Is that our legal tradition in this country?
No, it's not. I mean, the notion of a parent being the primary authority, forget educator, authority over their children is a long-standing principle. Here in Canada, under common law, parents are presumed to be acting in the best interest of their children. And unless we can show otherwise, what the parents say usually goes. And that goes with respect to education, sports, where they would live, whether they would travel, and so on. So it's interesting to see, as you're mentioning, this shift to this notion of co-parenting. When I was there last week, I actually overheard the lawyer for the other side say, well, we have to think about the board's rights. So
the board has rights over my children.
Apparently.
Even if I don't surrender them.
Apparently.
Okay. How did you get any sense? I know it's always tough to tell when you're in a courtroom. Were there judges asking questions? Did you get a sense of where things might be going?
Well, this wasn't before a judge. So this was just the lawyers and the parties with a court reporter. Okay. And we were just questioning. Everything, of course, is transcribed. And this is to be used at the hearing in front of a judge.
Okay, so the outcome of this, if it goes in your client's favor, will other parents be able to use those proceedings as part of their fight? Because I imagine whether you're in Hamilton, Ontario, Red Deer, Alberta, Laval, Quebec, you would have the same problem going forward and saying, look, you're infringing on my rights as a parent. You are trying to dictate something that my family does not agree with. Would they be able to take Steve's case forward if he wins and say, look, a judge has ruled on this. This is how things should be laid out?
Well, yes and no. Yes, in Ontario. Parents in Ontario will definitely be able to turn to this as a precedent, presuming we win. And of course, we're confident that we will. Parents in other provinces can look at it, but it's not binding on any court or any body. It is persuasive, but it's not binding. Of course, if and when this gets to the Supreme Court, then it'll be binding all across Canada.
So, last quick question for you. Is this how parents are going to have to fight back from the encroachment of the educrats, is going to court, seeking declarative judgments and pushing back that way?
Well, unfortunately, they won't have to do that on a continuing basis. The goal with this case, in part, is to make it so that we don't have to fight these battles again in the future.
All right, there you go. Albertos Polygopoulos, thanks so much for joining us today.
Thank you.